Hello, I'm Barrister Daniel Barnett, and if you want to do the best job possible at an employment tribunal, I think I can help. Because I've gathered together some of the brightest and best barristers who, between them, boast nearly 100 years of tribunal experience. And all of them, young, old, and even older, are sharing their reflections and insights into how to get the right result. Their top tips can make all the difference between losing, winning, and winning with style and ease. So listen carefully. They will say this only once, but my advice is to watch it twice. Enjoy.
My tip is to make sure that you keep as your mantra preparation, preparation, preparation.
Preparation, preparation, preparation.
Preparation, preparation, and preparation.
To be a great advocate, you need to know your papers inside out. You need to make sure that you understand the issues that the tribunal will be deciding, as well as all the evidence. And ideally, you should know these better than anybody else in the room.
The starting point in your preparation as an advocate are the legal issues. You must rigorously identify what they are. You must then analyse the law and apply them to the facts.
Always prepare for your employment tribunal with a short note of what the case is about. Set out precisely what the issues are in the case, and if you have to make legal submissions, set them out as well.
Your notes must be in a usable and appropriate way that you can turn anything up at a moment and that you can rebut anything that's said.
So when the judge says, how long are you going to be in cross-examination of Mr. Bloggs, you've got the answer at your fingertips.
There's a real virtue in keeping it short and keeping it simple. If you imagine that what you're saying needs to be understood by a smart layperson, a litigant in person, even if it's counsel on the other side, you're not going to go too far wrong.
There's a tendency, especially in very junior practice, to feel like you need to sound clever and make things sound complicated. But the best barristers do the opposite. If you're making opening submissions, if you're allowed to, keep them very brief indeed. Just headline what the case is about and what the evidence is, perhaps what the law is.
Use case law sparingly. Unless your case is particularly novel, odds are that the principles you're relying upon will be accepted and uncontroversial.
Don't re-examine unless you absolutely have to. It is very rare that you are likely to undo any damage that your witness has caused in cross-examination by re-examining. And in many cases, you will either just allow them to dig themselves even further into the hole or highlight even more to the tribunal your case's weaknesses.
And when you're closing, use short sentences and keep the entirety of the closing as brief as possible.
I think the most important tip, and I'm talking about written advocacy, which I'm going to stick to, is keep it short and as simple as you can. That's it. Think really hard about structure. Think really, really hard about structure. Use headings in Word or some other method of outlining so that you can see your structure at a glance and fiddle with it.
If possible, follow a set structure, whether that's the list of issues or organising your submissions chronologically. But whatever your choice, make sure you follow it consistently so that it's easy for your tribunal to follow.
Preparing a chronology the first time you read the bundle and including anything that could be of possible relevance is my single best tip.
It's really important to draft the list of issues for an employment tribunal hearing correctly. And that's because once you've got a good list of issues, it means that you have a way of knowing what the case is about. And if you know what the case is about, then you know what you need to prove, and then you know how you're going to prove it. And that is the route to you winning the case.
It's so easy to forget that the tribunal needs to see all of the elements of the legal test that you are trying to prove. And keeping that front and centre in everything you do will really help focus your claim and focus your ideas throughout the tribunal process.
We're going to have more tips in just a moment, but before that, if you want immediate access to explainer videos on UK law, whether it's employment law, family law, criminal law, or just my regular explanations of the stories in the news from a legal perspective, click subscribe and make sure you click the notification bell. I'll give you 4 seconds. 4, 3, 2, 1. Great, thank you. Let's go to Naomi Ling.
It's very tempting, particularly when you're starting out, to get into an argument with the witness if you don't get the answer that you're hoping for. This is rarely effective. The best thing to do is to build up to your question with all of the evidence that is relevant to it, and then put your final question. If you don't get the answer you want, the tribunal has seen why you're saying the answer should have been different.
It's something that comes with practice, and it's something I'm certainly still learning. But you have to remember that you're there to do your job and ask questions. You don't have to answer the witness's questions. If they respond to your question with a question, you can legitimately reply with something like, I'm afraid you have to answer my questions, but I don't have to answer yours, and then repeat your question until they answer it.
My general advice to witnesses is the structure of their answers should start with an answer and then an explanation. So yes, no, maybe, I don't know, or perhaps, and then explain why. And the reason why that structure is fantastic from my perspective, and usually from a judge's perspective, it's clear the witness is answering the question. They've said yes, they've said no, but they're also explaining.
Also, when cross-examining a witness, being polite and humane and smiling will sometimes disarm a witness, meaning that they can be less defensive and will give you the answers that you want. But if they don't respond like that, and they are defensive or angry or shouting, it'll make them look even worse if it's in contrast to your polite, smiling questions.
No doubt there will be lots of differences between the parties. You or your client may disagree with many things that the other side say, but unless it's an important part of your case, or it's something that would go to the credibility of a witness, something that would seriously undermine their evidence, then consider whether or not you need to use valuable tribunal time.
Don't expect to win cross-examinations, but do make sure you do them thoroughly and fully, and it will move the dial in your case.
And remember, if the tribunal isn't following and taking down the answers and the questions, it's as if you never asked it.
Politeness in tribunals doesn't cost anything and can really smooth the wheels.
Whether you're against a barrister, a solicitor, or someone representing themselves, I cannot emphasise enough how important it is to be friendly.
So if when you feel the temperature's rising, you take a deep breath, count to 5, you might ask for 10 minutes to go and see if there's any decent coffee in the coffee machine, but try and behave to others with the politeness that you would like to have displayed in your own direction.
Wherever possible, take the reasonable view. Try and agree timetables for exchange which take into account the circumstances of those who will be affected by them.
Always be nice to the tribunal staff. You never know when you're going to need a favour from them. And they do remember people who are less than polite to them. And something else to bear in mind is word often gets back to the judges, and if you are a regular tribunal advocate in particular regions, it is hopeless to your clients' cases. If you get a bad reputation, it's very difficult to lose it once you've got it.
If you can lighten your submissions with a joke or some self-deprecating reference, then it makes everything more palatable to the tribunal. But if you can't carry it off, one of the most dangerous things is telling a joke that falls flat. So there is a risk with that one.
Always remember that your task is to persuade the judge. That's what matters. That's the job.
Make good use of the first paragraph. It's extraordinary how often lawyers writing skeleton arguments fill up the first paragraph with a lot of what is essentially junk or infrastructure.
If the submission is simply put, it's more likely to be easily accessible and more likely to stick.
Tribunal hearings aren't recorded, there's no transcript for the panel to refer to, and so they have to keep detailed notes of any oral submissions that you make. The old tip used to be to watch the judge's pen. In these times, it's just as likely that the judge will be typing, So keep an eye on that as well.
Don't expect to bludgeon a judge to go with you. Don't expect that you can use the law or overwhelming facts to ask a judge to find for you. What you need to do is you need to persuade. You need to be emotionally connected to the tribunal. You need to understand what they want. You need to listen to their questions. You need to make your case as attractive as possible. And you need to make yourself, in some terms, likable.
You can waste far too much time trying to show that you're cleverer than the other lawyer, or you're better at cross-examining the witness than they are at answering questions. But in the end, what matters is persuading the judge, and that's what you should focus on.
Always have clear in your mind, what story am I telling? What narrative do I want the tribunal to hear? If you keep that in mind, you'll get it right.
So there you have it. Not so much the art of war, but the art of law. Be prepared, know your case, stay focused, keep it simple, and whatever you do, don't lose your head. Thank you to everyone who contributed to this video and who lifted the lid on what can be a trial for all of us, a trial in more ways than one. Now, for more videos about employment law, click here. This is one of my favourite videos, and this might make you laugh. I'm Barrister Daniel Barnett. Thank you for watching. Bye-bye.